Hi there. Thank you for joining us for the next talk in our current series on legacy planning. The subject of this talk today is wills, wealth, and the taxman, and it is going to be led by Catherine Hill, who heads the art and cultural property team at Forsters LLP, leading London law firm, where she's been a partner since 2008. She has many years' experience acting for living artists and their families, including several leading contemporary figures on legacy, succession, and taxation issues. Catherine also advises collectors, galleries, and museums. She has lectured in recent years at the Royal Academy on legacy planning and on art law matters generally. She is a member of the PAIAM, Professional Advisors of the International Arts Market, and the Heritage Lawyers Group. She acts as trustee and executor for many of her artist clients. Catherine is a founding director of Artistate Ltd. Thank you for joining us today, Catherine.
Thanks, Aretha. So I will share my screen and we will, if I can find my, here we are. Start from the beginning. So thanks very much for that introduction. So as well as working for Forsters, I'm also a director of Artistate, you can see on the screen here. And that's a business that we set up about 4 or 5 years ago now. And it was in order specifically really to help artists with any aspect of their legacy. And so that nowadays can be helped with cataloguing and archiving, but business structuring, reviewing contracts. But from my perspective, mostly wills and advising on sort of tax aspects. Importantly, though, it's not a law firm, but you can see the directors on the slides here. And we are a mix of lawyers, accountants, and ex-gallery owners. So between all of us, we've got lots of experience in the art world. And the point is to try and give an artist a holistic view of everything and then point you in the right direction for getting advice on whatever aspect it is. So I thought today we'd start with semantics. What do we mean when we talk about an artist's estate? Well, in conversation, we tend to mean the body of work that an artist leaves when he dies. But in the context of a will, in the UK, it means something quite different. It's your worldwide assets. So not only your artwork, but the house, the studio, the car, everything else. And you can see the legal definition on the screen here. But I thought it would be helpful today because of the audience to give us a sort of wider context, because I know that ACS and Bridgeman help artists worldwide. And in the UK, we've for many years applied this concept of domicile. And I remember asking clients in meetings, well, where would you like to be buried, as a test of where they felt their permanent home was. And that would determine in a rather loose way, of some case law, whether your assets were going to be subject to tax in the UK when you died. And those rules changed last year in the UK. And now a person who's been tax resident, so that broadly means they've been here 180 days or more in a single tax year, and they've been here for more than 10 out of the last 20 years, then they will be subject to inheritance tax on their assets worldwide when they die. And you can't just move out of the UK and become instantly non-resident, I'm afraid. So if you are thinking of leaving or indeed coming to the UK, then you do need to take some advice on that. And today I'm going to be focusing on UK law for long-term UK residents. And I'll be bearing in mind that the UK is a common law jurisdiction, like the States and Canada. And the underlying principle in these countries is that when you're writing your will, you've got something called testamentary freedom. So I could give my assets to anyone I wish, although there are some protections that exist. But civil law countries like France and Spain, or Latin America, Sharia law countries, they all make fixed provision for family members, and those can't easily be overridden. And it's important that you know whether any of those other countries affect what you're doing when you're writing a will. So if I had a house in France, for example, I can't just leave it to anyone I like, unless I take some special steps, which I'll mention later. And if I'm not able to do that and I just rely on the law in France, a quarter of my house in France would pass to my husband when I died, and three-quarters would pass to my children. And it's not just succession and tax that's specific. There are other differences too. I mean, France, for example, doesn't have this concept of executors at all, and the heirs inherit automatically when someone dies, and they don't have a concept of probate like we do in the UK. But since 2012, in Europe, it's been possible to try and effectively align the different countries so that there is now a solution for me and my French house. If I include an election in my will, I can elect for the UK rules to apply to my French house, and I can leave the entirety of it to my husband if I want. And that's good because it will be exempt from inheritance tax when it passes to my spouse, instead of finding that a quarter passes to him and I've then got tax on three-quarters of the property. We'll come on to tax in a bit more in detail in a minute, but for now I thought we'd focus on the UK and just think about an artist who's got no will in place yet. And actually in the UK, more than 50% of adults don't have a will, which is a pretty shocking statistic. And what happens to them is that their assets are distributed in accordance with the intestacy rules, and it's essentially the closest family members that inherit. And you can see the order of inheritance set out on the slide there. And those people who inherit are also then going to step in as administrators, so acting like an executor. There are some special provisions that protect you if you're a surviving spouse. And you can see again on the slide that if I died, my husband would inherit all my personal belongings. He would also inherit investments or cash up to a value of 322,000. And then the rest of the estate would be divided. He would inherit half on trust, so he wouldn't be free to do what he wanted with it. And the other half would then pass and be shared between my three adult children. Now, if he had died, and only our children survived, then they would take the estate between them. And if they had died, then it would pass to grandchildren. If they had died, to my parents, and so on, as you can see on the slide there. I did want to mention just 2 points, which just in passing, you can see the words personal belongings there. This doesn't include business assets. So if you're a working artist and you're making regular profits and you die, then your work is not going to pass to your surviving spouse, which is what you might think. It would actually fall to be shared, much like on the slide, between your spouse and any children that you have. And that's just going to make things more complicated because everyone would need to be involved in the decision making. The other point I wanted to make on this slide is just to highlight Fred Yates. You can see that rather beautiful picture of Antibes, which may be obscured by my mugshot at the moment. Sorry if so. But there was a very good article in the Art newspaper in 21. He died quite a long time ago, in 2008 now, and he was fairly typical for an artist in that he had found a home in France, and he also had a home here in the UK, and he had both belongings and paintings in both countries. And he was on his way back to settle permanently in the UK when he died of a heart attack. The unfortunate thing was that he was intestate. And what happened to him is that the French authorities sold all his paintings and his belongings in a flea market, which effectively meant that half the estate disappeared that way. And the other half, the plan was to persuade DCMS and Cornish museums to accept the paintings, which they were happy to do. But unfortunately, our legal department, the government legal department, blocked that move. So it was an unfortunate story all round. And the moral of the story, as you can guess, is that if you sign a will, you're effectively taking control. You can choose who manages your work, you can leave instructions about your wishes, and you can get the best tax treatment, which essentially then is going to give your work the best chance of longevity. Just to bear in mind, though, a will doesn't apply to joint assets. So if you own your home jointly or bank accounts jointly, those are going to pass to the other holder automatically on death. They're not going to be governed by what you say in your will. So I think before you start signing a will, just check how much joint property you've got. It is possible to alter that arrangement. And then the other thing to note is that a will doesn't govern your pension, which I suspect you realise, and also sometimes insurance proceeds are held in a trust instead. To sign a will, you've got to be over 18 or 18 and over rather. You need full mental capacity and you've got to have two witnesses. And they can't be beneficiaries under the will. That's very often a problem. Sometimes you read of these mistakes in the press. So it is important that you realise that and you ensure your will is validly signed in the UK. And also to highlight, rules abroad are different. It's certainly not the same in France, for example. So just be alive to that. I think the last point I want to make about a will in general terms is that it's a public document. When you die, your executors have to complete an inheritance tax form, and then they send the original will off to the probate registry with a statement of the sort of net value of the estate. And that is then filed and can be accessed by any member of the public. But it's not all bad news. There are ways to keep your wishes private, and a particular form of will that we recommend for the clients of Artistate and indeed of Forsters, which I will come on to in this next slide. So wills can be structured in several ways. And I guess the most simple version would be to leave some legacies to some named individuals and then divide the remainder, perhaps in percentages, between different members of the family. And that is, of course, absolutely fine. But it may not be fine if your circumstances change and you haven't kept your will up to date. You can instead have a will that sets up a trust, appointing trustees, and you ask that they follow instructions that you've set out in a letter of wishes. And the important point here is that letter of wishes doesn't go to the probate registry. It's private, and it's also flexible because you yourself can update that letter whenever you want to. The other point I want to make with a simple will is that the people you give your assets to, if you give them to them outright, are of course free to do whatever they want with those assets. That may not matter if you trust your partner, but you may find that third parties have access to your assets too, because if your surviving partner meets someone and they remarry, or even if they cohabit just for 2 years, then that third party can have a claim on your assets when your partner dies or gets divorced. So actually, will trusts are much more common than you think, primarily for this reason. And just on a practical level, one of the artists I represent, she wanted to leave her estate, and her will that she had when she met me simply said, I leave it all to my 3 children in equal shares, absolutely. Now, the children were definitely the right people to deal with the legacy because they're intimately involved in her day-to-day work and running her studio. But if one of them died, I pointed out that her estate would be shared between the 2 surviving adult children and then potentially a certain number of grandchildren. So when you're dealing with museums and galleries or issuing loan agreements or signing contracts, that's going to make things really quite tricky. So what is a will trust? In its simplest form, the will states that all your assets are left to trustees to manage at their discretion, and they can do what they wish with income and capital. It might name a couple of beneficiaries, but it also gives, generally speaking, the trustees the ability to add people afterwards. And then in a letter of wishes, the testator, or you, the artist, will set out in more detail what it is or how you would like to see your estate divided. And as I've said, the important point is that this letter is completely private, and the trustees will then use that as guidance for making their decisions. But I would stress the letter isn't legally binding. So it does mean that the people you name as your executor or your trustees, they're often the same people, will have the final say. Then on this slide, you can see there's a reference here to the 2-year window towards the bottom there. And in the UK, will trustees of the sort I've described have 2 years after you die to decide exactly how the assets in the estate should be allocated between family and other beneficiaries. And what they then do is to sign a deed, a short document, which they file with HMRC. And HMRC treat that document as if it was written into the will right at the beginning. So you can see that what you're allowing your team of trustees to do is consult with the family and other people and try to reach a decision that will reflect broadly what you're aiming for, but in the best way in the circumstances, looking at the assets and looking at the tax regime at the time. So it's a nice flexible way to effectively delegate decision making. I think when people hear the word trust, they often assume this is some long-term structure and they associate it with landed estates and the gentry, but it very often isn't long-term. I mean, last week, for example, I met a Royal Academician and his wife, and they're in their late 70s, and they don't want a long-term trust, but they're just not sure if they're still going to own the main asset in their estate, which is their house, which has got all the studio space incorporated into it, and it's quite a valuable property. And they also don't know whether their daughter is going to need the entirety of the value of their estate because unfortunately she's terminally ill. So really having the ability to say to the trustees, this is broadly what we want, and can you try and achieve it depending on what you think is best? That's the solution for them, because their long-term objective is to leave the studio to a charity that runs studio space for artists. But that will only go ahead once they're clear that the family members have enough, essentially, to survive and achieve what they need medically, particularly for the daughter. So they're delegating their decision making. Sometimes the will trust does continue, because you can imagine that for every artist, they've got the sort of financial side of their lives. And there I'm thinking possibly some savings, investments, property. And those typically will pass to family members. But when you're thinking about the artist's practice, it needs a long-term holding vehicle. And not every artist has a ready-made company that's in existence. Many artists are sole traders today. And what the will trust does is operate very much like a company, because it's giving the trustees the legal right to manage the artwork and effectively to then, after your death, negotiate perhaps with institutions placing the work there. In fact, it's worth saying it's not always museums or famous galleries. A lot of clients for their lower value work are looking at hospitals as a good place to take the work and ensure that it's seen by the public on a regular basis. And your trustees alongside that might be able to continue the practice in your studio if perhaps you're producing prints and there are edition runs to make. Sometimes they'll be able to find galleries after your death to represent you who are interested in putting on exhibitions and keeping your legacy alive. So I've touched on the letter of wishes. And what might that say? Well, typically, it sets out some fairly sort of practical matters at the beginning, and it will very often state whether you want to be buried or cremated and perhaps give details of a service. Then it will move on to thinking of or setting out legacies you'd like to leave, perhaps to family, godchildren, whatever it might be. And then for an artist, they need to decide on that dynamic between the family and the artwork. And a key part of the planning for an artist really does involve an inventory, a catalogue, so that you can break your work down into categories. I think Jessica might have touched on this in the last session, but identifying those core pieces that you want to be kept and the sort of supporting work, I sort of think of it as endowment work, that's going to help tell the story of your development of an artist if an exhibition were to be put on. That all needs to be identified to third parties who may not know the work like you do. There's archival, there's the preparatory work, and then I think importantly the pieces that you wouldn't mind losing, that if trustees or family have to sell in order to sort of produce an income to help manage the ongoing activities, that's all important and it needs to be noted down. We encourage artists at that time, when they're putting the inventory together and doing their letters of wishes, to set out who their contacts are in the art world that they trust. So it might be your current gallerist, or it might be friends from art school. It can be all sorts of people. But if you're naming someone to manage your artwork after your death, to know who your trusted advisors are currently is very important. And that needs to be captured on paper. As an artist, you then need to think about what can the family inherit immediately in terms of cash and investments? And are there any particular works you want them to have personally? And then how will the remaining artwork be managed? Is it going to be held and run? And is there the prospect of you making funds after your estate, after your death, from sales? And will those funds then further support family members? Or perhaps do you want to do something else with that, like support struggling young artists? I mean, very often artists would like their studios to be used by people who are right at the beginning of their careers. Likewise, I've had many artists say that they'd like to leave legacies to places like the RA, institutions that have supported them along the way, charities. So alongside that nutty problem, artists also need to be thinking about copyright and the ways in which they would feel comfortable for images of their work to be used after they've died. And actually, I've come across families of certain artists who fiercely protect this and are always vetting what kind of publications or news stories the images might be accompanying, and ensuring that they have the right to veto the use of the image if they feel that it's wrong. And you probably know the sale of an artwork during your lifetime doesn't transfer copyright of itself. And so typically copyright still lies with the artist and their estate on their death. The example here on this slide is Paula Rago's portrait of Germaine Greer, and that was actually commissioned by the National Portrait Gallery. And because it's a commissioned piece, you may know actually the copyright there sits with the MPG rather than with Paula. And it can produce an income stream, and for some artists, it's a very healthy one. So thought needs to be given as to where that income is heading. Is that something that's supporting family? Or is that something that you feel would be right to help support the arts industry generally? Again, should it be something that feeds into a particular charity within that sector? Separately, of course, from copyright, and obviously the team on the screen with me know all about this, as artist resale rights. Quite separate from copyright, and it applies where your work is sold in the secondary market for a price in excess of £1,000. There's a sliding scale. If you're lucky enough to sell pieces at 2 million, then you're capped off at 12,500 as a payment, but it's a useful income source. Slightly different from copyright in that you can't give away artist resale rights during your lifetime. It is something that only passes on your death, so via your will, either to family members or charity if you choose it. So really what we're saying for an artist's letter of wishes is that they need to take stock of the situation and try to get it captured on paper as to what they would do today or what they would like for their best scenario for their work today. So if you can get cataloguing now, then that's good. We need to get started with that using Art Logic or even a similar package or an Excel spreadsheet even. Recording the works with good quality photographs, dimensions, location, very important, and ownership. If you've sold it and you've got the buyer's details, great. I know with GDPR that's quite difficult these days. But so often, both at Forsters and Artistate, we meet with families where the works are distributed between home, a studio, storage space, possibly hanging on the walls of children, some friends, and that's a tricky task. But if you've got a list, that's going to help everybody. And as I say, instructions as to how you categorize that works, which ones are the important ones for you, and which ones would you be happy to see sold to help support others within the family or whatever else you wish to do with your estate. But it is a living document, this, and it needs constantly refreshing. Staying with Paula Rago for the minute, her son told me that they had found a whole stash of Paula's pastels not so long ago, rolled up from a period where they were self-portraits, and she was feeling low, and I guess she'd rolled them up and hidden them away. And artists tend to do that, don't they? So I'm sure all around your various spaces there are pieces that you might have forgotten about. So it's a work in progress. So that's a little bit about the structure and the letters of wishes. So what's the task of an executor? Just so we understand the job at hand. So an executor in the UK, their job is an administrative one. They work with lawyers to confirm what assets there are in an estate and to get them valued. Then they complete the inheritance tax form, which gets sent to the revenue. And alongside that, they then apply separately for probate, as I said, sending off the will to the register. And once they get the grant of probate, that then authorises them to deal with the assets in the estate. Now, if you've got a simple will that only makes outright gifts, then all you need to do as an executor is organise those transfers. So if the house is going to the children, update the land registry. If there are shares that have certificates, get those updated, get the artwork handed over physically. If, however, you've got a will trust, your executor role comes to an end at the point when you get the grant of probate in, and then you hand over to the trustees, who are very often the same people, I might add. It's quite hard to think of executors and then separately find another set of people as trustees. But the role of trustee is quite different. You've got a long-term duty as a trustee to manage interests in the best interests of the people who are named in the will. So as the artist or the person who's signing a will, think carefully. The clue's in the name. You've got to have people that you trust implicitly, who know your family and your work. And you can have two sets of trustees. Sometimes artists will do that. They will choose their close companions in the art world as trustees for their practice, but they might have family and friends acting in relation to the other investments, the houses and so on. Whoever you choose, they need to be people who can act correctly if a conflict arises. And you might be wondering why we're looking at a picture of Mark Rothko here. Some of you may know the story already, but Mark Rothko committed suicide in 1970. And he chose, probably sensibly in his view, his executors to be his accountant, who, by the way, advised the Marlborough Gallery, and an artist friend who was contracted, or I think in the process of being contracted, to the same gallery. Between them, they didn't do their finest job. They sold a huge number of works, I think it was 700 works, to the gallery at low prices, I mean, way off market value. And unsurprisingly, they were sued by Kate Rothko, his daughter. And the two executors were found guilty of self-dealing, essentially lining their own pockets, doing something that they profited from themselves, and were sued for $18 million and $19 million respectively. So a very cautionary tale. And I think what it does is it illustrates take care with your choice, but it also illustrates that when things go badly wrong, you're going to need court involvement to deal with trustees who've just crossed the line. And sometimes it can be hard to prove the line they've crossed, because in the UK, poor investment decisions or being slow and useless is never quite enough. It can be, but it needs to be very extreme. So as I say, that the choice is critical and it always needs refreshing and updating. So let's change topics slightly. We're going to look at tax now. I always think of this as a relatively simple tax because it's a flat rate of 40% in the UK, and that's chargeable on everything over the first 325,000. So everyone's entitled to this nil rate band, as it's called. But you just need to bear in mind that if you have made capital gifts within the last 7 years when you die, and if you're going to leave some chunky cash legacies to people who aren't your husband or wife or civil partner, then you could be eating up this nil rate band. So if I gave my son 2 years ago 100,000, and then I give my 2 other children 100,000 in legacies in my will, there's only going to be 25,000 left to offset the tax in the rest of my estate. Now, in my case, that won't be so bad if I die first, because I will be survived by my husband. Now, he's an exempt beneficiary, And if I ensure that the rest of the estate passes to him, either outright or on one of these will trusts I told you about, where he enjoys the income, there'll be no IHT to pay. As you can see, the other form of exempt beneficiary is charity, which is linking back to that couple I mentioned in their 70s who are wanting to leave charity to their studio to a charity. There are some also special exemptions for the type of asset, and they're shown on the slide here: AIM shares, business property, agricultural, and heritage. Now, we've seen a lot of changes to inheritance tax recently. AIM shares and business property and agricultural, they used to be 100% exempt. So farmers and indeed working artists never needed to worry about inheritance tax on that part of their estate. But from the 5th of April this year, business property, which is the one that really relates specifically to artists, is now subject to a cap of 2.5 million. Now that's generous for most artists. So they ought not to be facing inheritance tax, because one would hope that the value of their practice would fall within that threshold. But I do have to say, I know a number of artists who might think that, but who own their studio, which happens to be in Hackney. And the studio is creeping over the £1 million mark easily. And when you look at some of the canvases they have, which are particularly large, they're actually not too far off that kind of number. So you need to have it in mind. When we're thinking about business property, there are two further questions for you as artists, working artists. The first of the questions is, do I actually have a business? Now, you might have a company or be a sole trader, but it needs to be something that you actually carry on for gain. So it's got to be a serious occupation and not a hobby. And some of the phrases that the revenue will use are that it's got to be actively pursued with reasonable continuity. And nowadays, making supplies to a consumer for a consideration. So if you're not selling, it's problematic. If you stop work or you get ill and you can't work, again, it's going potentially to be a problem. And we often, in addition to considering this, have to consider what is actually owned in the business. Very often, accountants will suggest to artists that they incorporate, and they set up a company because the tax rates are lower. But if you set up a company in, let's say, 2000, and it was done without too much thought, and this does happen quite a lot, there's no clarity at that point as to what actually went into the company. So very often we find there's no record, and we have to assume we've got a company for works after 2000 and probably a sole trade for the early works before 2000. So there are some subtleties here. And then we need to come on to, assuming you have a business, what's it worth? And this is the valuation question, which was highlighted in the points about this talk. So in the UK, we have to work on an open market value for all assets. And if you're the revenue, you'll be doing your research, looking at the auction prices in the secondary market for any artist who dies. It's difficult because if work hasn't sold in the secondary market in any volume, then it's not a hugely reliable guide. So a valuer has to come in with a figure that's based on a hypothetical sale for every piece that assumes you've got a willing buyer somewhere. The important point I want to stress is that the price is very rarely at gallery levels. Those are usually aspirational, and of course they include 50% or whatever the percentage is of gallery commission. The valuer's got to come to a figure that's reasonable in all the circumstances, and in the UK we're not allowed to apply what the States calls blockage, meaning a discount because we're throwing everything into the market at once, which is going to lower the prices because there's so much available. So what can we argue to get the values down? Typically, when we're debating the point with the revenue on a death, we'll be saying that the auction prices that they were looking at are actually out of date because the market's moved since then, that we have got private sales that they don't have access to that show lower prices, that there's always a proportion of work for any artist that just isn't sellable. It's unfinished, it's not it's not appropriate for the market for whatever reason. For sculptors, most typically problems with condition, and prints, editions. What run of editions? Are they large numbers or are they small? And Christea Roberts traditionally have been very helpful in guiding us and others on that point. So I think if your practice is likely to be worth less, significantly less than 2.5 million, you don't have too much to worry about in terms of the inheritance tax. The works should be exempt. But if it's closer to the 2.5 threshold, then care needs to be taken, and all those points I've just mentioned need to be thought about professionally. I want to make one point here in relation to heritage property. We often think of heritage property being a stately home, open to the public with a holbein on the wall, and the contents enjoying special exemption because of the cultural importance to our nation. And of course, that's true. But actually, it applies to individual works as well. And each year, items together worth about 50 million are exempted from tax in this way. Artists I've worked with have pieces in the Tate, Scottish National Gallery of Modern Art, National Gallery of Art in Wales. It can be anywhere, and often they own works by their contemporaries as well, perhaps with a higher profile in the art world. And if the works are considered to be of a suitable standard, the word is preeminent, then they can qualify for this thing called acceptance in lieu. Essentially, the work is sold to the nation after your death in return for a credit against the inheritance tax on your estate. And Artistate recently helped the estate of Sue Dunkley, and they had two works which were purchased for the nation. One is at Pallant House, and the other is with the Tate. And her work, interestingly, was not particularly well known at the time of her death, in that she had been unable to work for a number of decades because she had suffered from dementia. But the interest in her work has revived significantly since her death, and I think it's a wonderful tale for those artists who feel that their profiles never quite reached where they wanted it to. Certainly for Sue, that's happened now. And also, one point I didn't mention on this slide, just going back to it here, the balance chargeable at 36. Do you see the last line of it there? If you leave more than 10% of your estate to charity, then the family will, assuming it's children or grandchildren, will be paying tax at 4% less, so not 40 but 36. And the couple I mentioned who want to leave the studio to the charity are likely to save about 150,000 doing that. So I thought we'd finish on foundations. It's a really complex area, and I think a lot of artists want to do something really positive with their legacy. It can be as little as just leaving a pot of money to provide grants for a few years to aspiring artists, or perhaps helping them find some studio space. And at a grander level, if you've got the funding, it might be about making your own studio available for the longer term, or preserving and promoting your own work, like Henry Moore, Bridget Riley, or Barbara Hepworth. I would just say, if you as artists are able to find a suitable pre-existing charity that's keen to take your work during your lifetime, that's going to make it so much easier. If you don't plan ahead, we know museums have got little space, and what goes into storage doesn't come out again readily sometimes. And I think artists will then think, well, I can set up my own charity instead. But it's a mistake to think you can do that easily. It's expensive. In my experience, it costs at least 10,000, upwards of 10,000 to do that in lawyers' fees for just the application process. And it's rigorous and it's slow. I mean, I act for an artist that's a household name who died 3 years ago, and the artists and children wanted to set up a charity, but they needed to be able to include selling some of the work as part of the purposes of the charity in order to make it self-sustaining. And the Commission just don't like that. They won't accept that selling the work is appropriate if the very kernel of your activities is to preserve the artist's legacy. And I can see that. So instead, they've had to settle for setting up a grant-making charity instead, and children surviving will donate profits from sales of the works in their lifetime to the charity. And then on their deaths, the key works will be transferred into this foundation, provided it's self-sustaining by then. And if you look at Bridget Riley, that's pretty much what she's done with her foundation. Her sort of annual profits from her business are donated to the foundation, promoting the research of her work and also drawing and arts generally. And actually, when there's money available in her charity, they buy works in from Bridget during her lifetime. And on her death, she will then transfer the rest, I'm sure. So it's a complex area, and don't assume it's something that you can do with any ease. So I think necessarily that's quite a canter through a lot of dense topics, and I hope I've shown there can be some pretty unattractive consequences if you don't have a will in place, if you haven't thought about cataloguing and got your inventory ready. And there are real benefits in thinking ahead for you and the family, just because there's less tax to pay if you get it right. Fewer opportunities for everyone to fall out and have disputes. And for your artistic estate, it's, if you have a will trust, having some flexibility and giving your trustees the chance to keep your work in the public eye, hopefully enhancing its value in the longer term. So last slide, action list. Create this catalogue, keep it updated, annotate it with the categories of work, what's important, what's not so important. Organise a will, preferably a discretionary one. And you'll see on my slide here, I've said sign a lasting power of attorney at the same time. That enables someone else to take decisions on your behalf if you lose mental capacity while you're alive. And generally, lawyers will do that at the same time as your will. Write your letters of wishes. Make sure that you keep it updated. And then if you are choosing executors and trustees, make sure you've spoken to them and that they're really clear. Words can't, orally translating or saying something can't really replace the written word. The nuances of having conversations, it's so important. And my last comment would be, if you feel that work should be in certain institutions, whether that's the local library or the Tate, try and take action to place that work in your lifetime just to make everyone else's lives that much easier. So that brings me to the end, and I will stop sharing my slides.
Thank you so much, Catherine. That was fascinating. And I know there were questions that were queued up for you, but you answered them throughout your presentation. But I will, at this point, say to our attendees, if you do have any questions, please do jot them down in the Q&A. There's hearts being sent, Catherine. I don't know if you can
Oh,
see
that's very
that.
nice. Thank you, everybody.
Okay. Yeah, lots of hearts. Wonderful. Yeah, I didn't actually know Zoom could do that, so that's good to know. Yeah, and a clap. It was really, really, really informative. So thank you so much. Um, you really have answered. This is the first time ever. There aren't any questions.
That's my job, you see. This is all I do these days. So I'm quite well versed in what comes up.
Wonderful. So this is our second of three talks. The next talk will be, well, it's to be determined actually, because I know we had some change with the dates, but Pierre Valentin will be taking that and the focus will be intellectual property. There'll be a reminder sent out to everyone who's registered. So if you haven't signed up, please do so. And with the registration, you'll get a video sent round of this talk, and there will be a link to the Artistate site. So
Yeah.
I think that's it.
And any queries, don't hesitate to make contact with Artistate. And even if we can't help, I'm sure we'll be able to direct you somewhere.
Well, we've got one person saying thank you so much, very useful. Um, Another person said, are you sharing the PowerPoints? We won't be sharing the PowerPoints, but the video will be circulated and that will have the slides on there. So I hope that answers your question, which I think it does. So very clear, thank you. Another heart, great. This is all great. All wonderful. So if there's nothing else, we shall leave it there. Thank you again to everybody who joined us, and thank you again to Catherine.
And
So
thanks
thank
for
you, bye-bye.
hosting. Thank
Thank
you.
you. Bye bye.
Bye bye.